We are ready to reconvene the public meeting number 76, which was temporarily adjourned on Wednesday. Today is September 6th at 1:30. And we will pick up with the open-ended topics, several, from the Ombudsman report when our Ombudsman gets his paperwork ready.
Thank you, Mr. Chairman. As you mentioned, we're going to continue discussion of the, as a first matter, the question related to the Penn National transfer of the host community agreement from Our Way Realty to Penn National. We received a number of comments on our website that are included in the Commissioner's packet. I have a summary in this paperwork that I've just lugged over, but one of the other matters was just pending. Sorry for my
No, I know that.
tardiness.
No problem, no problem. We understood. Take your time, John. It's no problem.
Great. I can do it from memory while I'm looking for the paperwork. But we received a number of comments from citizens on both sides. Well, actually, on a number of different sides of the issue related to the potential transfer and the Commission's consideration of that transfer. It was essentially almost an even breakdown of comments between comments that we received in support of the transfer, and then if one would group both a request to disapprove of the transfer and a grouping of comments that asked the Commission to delay the 60-day, delay the transfer, delay the election for 60 days.
Delay the referendum from 60 days from the sign, from the new applicants.
So if you were to group those two, it's essentially even. But on the specific no's, it is much less than that. I believe it was 13 citizens wrote in on the specifically stating that they do not support the transfer. And then I believe it was another 13 that indicated that that they would like to see a delay in the vote by the Commission.
And about the same number were in favor of the transfer.
And which one?
Total,
Yes,
yeah.
correct. 20. I believe it was 26 that were in favor.
There was a significant number of opponents who were from Foxborough.
Correct. That's absolutely true. So among the, I'll give you a flavor of some of the comments that we received. On the no side, people said, not an applicant, they know very little about Penn, 60 days, they've been unvetted. One citizen referenced that the 60 days might be useful to citizens groups that do not have the wherewithal or the resources related to the election. 6 people say that a 60 days is too brief. Only last night there was a forum with Penn. As I noted, many said postpone the election. Some said that this potentially could undermine the Gaming Commission's rules. Others had general concerns regarding the facility. Traffic was a concern. Others had noted that Plainville was Plain Ridge was a very known commodity in the community for many, many years. Others had simply said, hey, there's no place for gambling in the community. Others, as you noted, there's many commenters from other communities, notably Foxborough, in saying that there shouldn't be anything near my town. Generally, people have said that it's especially important to other towns to understand impacts, and that is the purpose of the 60 days. Some of the flavor of the yeses were that it is important to support the town's ability to vote. The Commission should support a democratic system. Yes, allow this transfer, but vet them. People expressed the importance of horse racing. People expressed that we should trust the voters. People expressed that there should be a lot of support for the local farms and horse farms. People expressed that this would have a significant impact upon the fiscal budget of the town. One commenter said that many businesses had closed in Plainville and that this should not be one more. People expressed that Penn are their experienced partners. People said that millions go to other states in revenues and that this should be brought back into Massachusetts. People said if the commission could visit Plainville, they would see yes signs everywhere. People have said, please do not let a small group to prevent a vote. Don't let minority rule, allow the vote. So those were some of one citizen wrote in, even though this means a lot to a lot of other people, what it means to that person was that his or her job would be saved. So that's sort of the general flavor of the comments that we received. We received some additional.
I want to reiterate that we do, every single one of the comments that came in on the website, we do have in our books. We've all read all of them, and we do appreciate the fact that a lot of people took the time to write in.
Great. And notably, we received some additional briefs from the Penn side. We received some additional briefs from the town side. And what I thought I would do is I would give an opportunity for Penn to come up and give a little bit more of an explanation of the questions, their answers to the questions that the commission raised the other day. So, Mr. Snyder, if you could join us. Mr. Snyder is the Vice President of Corporate Development for Penn National.
Thank you, Mr. Ziemba, and thank you, Mr. Chairman and members of the Commission. Again, my name is Steve Snyder from Penn National Gaming. We very much appreciate the deliberation and the consideration that you have given and are giving to this very critical matter. I spent 3 hours last evening at a community forum in Plainville. I can tell you it was very well attended. It was also televised locally through cable access, and a vast majority of the folks who were present spoke very favorably in response to this project, in response to this location. I've brought with me today our outside counsel, Jonathan Albano, to my right from the Bingham Law Firm, who did draft and submit the letter that you have in front of you. Along with Jonathan, I have to his right Mr. Joe Ferguson, the manager of the town of Plainville, and further down the panel, Jonathan Silverstein, who wrote the letter on behalf of the town. So I'm going to ask Mr. Albano to address our letter, and then, if you wouldn't bear us the indulgence, also ask the town to address the matters addressed in their letter. So thank you very much.
Before Mr. Albano begins, because the record ought to be clear on this, Mr. Albano and I were partners in a law firm 27 years ago, actually longer than that now.
You joined that firm when you were 7.
When I was 7. It's a different law firm now than it was then. Still a fine law firm, but I've had no contact or relationship with the firm since I was appointed to the Superior Court. And
When was that?
That was in 1985, and severed all relationships with that firm since then. And I've had little contact, frankly, with Mr. Abdelnour since I left.
If I may, before I turn it over, I apologize, I misspoke. It's Mr. Fernandez from the town who is with us today.
Let me just say one thing. We do want to hear from you as well as other folks who have signed up to speak. In the interest of time, but also just for what's really going on here, the issue should be targeted on the question of the transfer of the applicant and the transfer of the HCA and the switch from one applicant to another. There are other issues, but those are the ones that we really want to focus on. I think you all heard what our questions were last time. Let's try not to trod ground on issues we already agree on. Like, for example, whether you can transfer the HCA, we don't disagree with that. No point trying to prove that point.
Mr. Chairman, if I finally, my paperwork is in my pocket. I could just give you the final numbers. I'm sorry.
Oh, okay.
So it was 36 in favor, 13 against, and there were 23 in favor of a delay.
Okay. Thank you.
Good afternoon, Mr. Chairman, Commissioners. If I could clarify one issue, actually, I was a little too young to have been Mr. McHugh's partner back in 1982. So
Well, you were
I-
something. You were on the move.
I was an
You were there.
associate at the time.
We worked together. which is-
Thank you. My plan and what I was asked to do was to address briefly the legal issue raised by the matter before the panel without unnecessarily repeating anything that has been submitted in writing to the commission. There may be, if to the extent other issues are raised in the course of today's hearing, we have others here who are, I'm sure, better qualified to address those. In brief, though, I think the summary of Penn's position could be stated as, in some ways, a defense of the Massachusetts state legislature, because our position is that when one looks at the statutory language, the context, and the purpose of the statute, it is actually quite clear that not only does the Act contain no prohibition against the transfer of an interest in a HCA, but that moreover, the Act does not contain any requirement that the electoral process be restarted upon such a transfer. And there does seem to be universal agreement, as Mr. Chairman stated, that interests in HCAs are transferable. There's also universal agreement that what the statute does is goes further, actually, by allowing transfers even of licenses after they have been issued, subject, of course, to commission approval. But to me, one interesting point, and, well, maybe not interesting, but I think significant, is that in the very subsection of the statute, section 15, subsection 13, that some are citing for the proposition that the word "the," when put in front of the word "applicant," means that the electoral process must be restarted. In that very same section, the legislature demonstrated that when it wanted to require the electoral process to be restarted, it knew how to say so and said so explicitly, because it is in that very same subsection that the legislature said, if there is a vote taken, if the vote is not in favor of a gaming establishment, then the applicant, I think the language that's used is, the applicant must submit a, quote, new request for an election that can't be made more than 180 days after the last election. So we do have clear evidence that when the legislature wanted to restart the electoral process, it knew how to say so and did say so unambiguously. If one moves on to the specific language of subsection 13 that is relied upon for the argument that no, if an HCA is transferred, the electoral process must start all over again. There aren't many it's not much language that's relied on, but each of them, when you look at them, has a clear and different, very different purpose than restarting the electoral process. And I will just give you two examples. The first time that you see the language, the applicant, that is cited by the opponent says, provided, however, that a request for an election shall take place after the signing of an agreement between the host community and the applicant. Well, I would suggest that if you step back and look at what is that section trying to say, what is its purpose? Its purpose, it's clear. It's just saying there ought to be a final agreement before the electoral process begins, because think of the havoc and the uneven bargaining leverage that would occur if the electoral process could begin before the agreement was finalized, period. That is the clear statutory purpose, I would submit, of that language. I'll give you one other example. There is another proviso that says, provided further that upon receipt of a request for an election, the governing body of the municipality shall call for the election to be held not less than 60 days, but not more than 90 days from the date the request was received. That, I would say, has quite a clear purpose, and the purpose is that there must be sufficient time, no less than 60 days, for the community to consider the question that the legislature required be put on the ballot. And that question, that the language that the legislature required is whether to permit the operation of a gaming establishment licensed by the commission located at X site. That is the question that was put to every community that holds this sort of an election, and that is the question for which the 60 days is required, and that 60-day period has been met here. The last point I would make is that it does seem to me that what is lined up against the statutory language, purpose, and context that I've spoken of now is simply the use of the word "the" before the term applicant in certain spots in section 15. But if you try, as I have done, to substitute a different word for "the" in those places, then you quickly see that the statute would have become quite confusing. Should it be an applicant? Well, which applicant? Could an applicant in the Western Mass make a request for an election that's not? It gets quite confusing. Substitute an, any. I would suggest that it becomes clear, again, when you think of what the statute clearly does do in the context, that this was simply a means of identifying the applicant in the process without conveying smuggling in to section 15 by use of the word "the" kind of intent that's been suggested here. I started out saying I would, in a way, be defending the legislature, because I do think that, viewed in context, it's clear that they did not require the restart of an election. I think I should close by defending that little word, three-letter word, "the," because it is asking too much of that little word to convey a legislative intent to require a restart of the electoral process, given, in particular, the very limited question, important for sure, but limited question put to the voters. And finally, I'd say, to the extent some of the arguments that have been made spill over into issues beyond what did the legislature mean in the language it used in section 15, policy arguments, I'm sure heartfelt arguments. Those arguments, I would suggest, are really reasons to hold an election and not reasons to cancel an election, especially in the context of this particular statute. I'd be happy to, if I could, address any questions now or later, but otherwise I would yield to Mr. Silverstein.
Questions, anybody?
Thank you, Mr. Chairman, members of the commission. Again, Jonathan Silverstein, Town Council to the Town of Plainville. I'd like briefly to address some of the points I raised in my letter to the commission yesterday. But first, I would like to address one factual point which I think is important to bear in mind, and Commissioner McHugh alluded to it. Ombudsman Ziemba noted that there were 36 letters in favor, 13 against, in response to the commission's request for comments. I would note that by our count, 7 of the submissions against, only 7 were from Plainville residents, whereas nearly all of the 36 comments in favor were Plainville residents. And I think that's an important distinction to bear in mind. I would note that, and I'll get to the issue of potential voter confusion or concerns about voter awareness in a little while. And I would note that while I'm sure the residents and voters of Plainville appreciate the concerns of Foxborough residents about their ability to knowledgeably vote on this matter, I think that the Plainville residents should have the final say on that.
Excuse me, Mr. Silversing. This screen, this monitor's not working. I assume that doesn't mean that it's not going out to the web.
No, it is.
Okay, all right. Well, all right, thanks. Sorry, go ahead.
No. I want to build, if I might, on Mr. Albano's suggestion that the reading that we urge the commission to give the statute is a defense of the legislature's intent in adopting the statute.
But don't tell us the same thing again.
I
okay?
won't at all.
Okay.
As I said, I want to build on it. I'm not going to repeat any of Mr. Albano's comments, but I think that he spoke very well to those comments. But I do want to build on it by noting that both the legislature and this very commission built in substantial flexibility in the legislature's instance into the statute, in the commission's instance into the regulations that you adopted under the statute, built in substantial flexibility to accomplish the purposes of the statute. And we all know, and we've discussed what some of the purposes of the statute are. And I think for purposes of today's discussion, notably one of the purposes of the statute is to encourage competition for the purpose of maximizing revenue and other benefits to the Commonwealth and to potential host communities and host regions. And I would cite to the Commission, Chapter 23K, Section 110, and the concomitant provision of your regulations, 205 CMR 102.032, both of which say that the provisions of the statute and of the regulations should be liberally construed to accomplish the purposes of the statute. I submit to the Commission that giving the statute the reading encouraged by some residents of other municipalities and some other applicants would not accomplish any of the purposes of the statute, would not accomplish any purpose at all except to eliminate competition, and would have absurd results. And that would be both inconsistent with your own regulations and the statute, but also inconsistent with generally accepted methods of statutory construction. And what would the absurd result be? The absurd result would be that a project would be eliminated from the competition for the Category 2 license solely because the entity proposing to run the project will have changed. And not because the entity proposing to run the project will have changed, but because of the specific timing of when that change will have occurred. There's no doubt that that change could occur post-licensure, post-vote, and the voters of the town of Plainville would have no say over it. Only this commission would have a say over it. And what possible purpose would be accomplished by saying, all right, now the voters have a week or 10 days of notice, and that's not enough, but it would certainly be enough when they had no notice and it took place after their vote. I submit respectfully to the commission that would make no sense at all. It would be an absurd result, and it's well settled that you should not read a statute to have such an absurd result. And I would note also that your regulations, 205 CMR 102.06, specifically contemplate, hey, we cannot envision every circumstance that may arise in the context of this brand-new industry that this commission is laudably grappling to regulate and establish a process for. And so what you did was you specifically built into your regulations a provision that says matters not specifically provided for in 205 CMR regarding the licensing of a gaming establishment shall be determined by the commission in a manner consistent with the principles of Chapter 23K, Section 1. Again, going back to the purposes of the statute. No purpose of the statute would be served by eliminating this project from the competition. And I would submit to you that pursuant to your safety valve clause, if you will, in your regulations, this is the poster child for such an unforeseen circumstance, and the only common sense way to accomplish the purposes of the statute would be to accept the substitution of Penn for our way as the applicant for this project. I want to address the issue of voter confusion. I addressed it the other day. I'm not going to repeat those comments, and I've addressed it in my brief, and so I don't want to repeat that either. But in Mr. Fernandez's own submission on his own behalf to this commission, and I know you've received an awful lot of comments, and just last night, so you may not have had a chance to read his submission.
We have.
Fair enough. Then, for the benefit of everyone here, I'd like to note one thing that I think Mr. Fernandez really spoke to very well. In Plainville, everybody knows what Plain Ridge is. It's a place. It's a project. It's an establishment. It's a brand. None of that. The place isn't going to change. The establishment that's being proposed is not going to change. The brand is not going to change. The owner is going to change, has changed. The owner has changed many times over the course of the years, and Mr. Fernandez noted some of the owners of that establishment. No one in town has ever considered, geez, let's go to Our Ways place. It's Plain Ridge. It's the Plain Ridge racetrack. None of that is going to change. And I would, if members of the commission have had an opportunity to look at the ballot that is before the voters, here's what the explanation says. As Mr. Albano indicated, the ballot form, the question form, is prescribed by statute, and notably, nothing in that prescribed ballot question refers in any way to the applicant or the owner of the establishment, and I think that demonstrates the division of roles that I spoke to the other day before the commission, that the role of the voters is not to determine suitability, as some of the comments to this commission last night have suggested. The ballot says, shall the town of Plainville permit the operation of a gaming establishment licensed by this commission to be located at Plain Ridge Racecourse, 301 Washington Street, Plainville. No reference to the applicant. In the explanation, it says a yes vote would allow the owner of Plain Ridge Racetrack to apply to the Massachusetts Gaming Commission. That's what everyone in town is voting on. They're voting on a project at a place that the owner of the racetrack will be allowed, if the vote is successful, to pursue before this commission. None of that is changing. No voter in town is confused by that. There's been, I would submit, more process subsequent to Penn stepping into Plainville that has alerted the voters and people of Plainville, to the extent that it even matters. For purposes of the statute, I submit it doesn't, but to the extent it even matters, there's been more process in the last week or 10 days regarding Penn to inform the voters about Penn's role here, about who Penn is. I would note last night at the public forum that that Plainville held, the town's independent gaming consultant, Will Cummings, who is an industry-acknowledged expert, and his associates, and Mr. Cummings is here if the commission has any questions of him, went into great depth and detail regarding who Penn is and what their background is, and noting the fact that, in fact, Penn would be an excellent applicant to pursue this project. There's been more process, I would submit, than in many of the other proposed host communities over the course of the entire election period. So to the extent that there is any concern there, I would submit there's been more than ample process. And finally, I would suggest that the notion by some of the submitters of comments that this commission can or should delay the election, I would submit as a matter of state election law. That's not something that anyone other than a court would have the ability to do. The notion that it would be delayed beyond the 90 days allowed by the statute, I think would be blatantly inconsistent with the statute. It would have one purpose and only one purpose, which would be to prevent Penn from filing a RFA2 application to this commission by the deadline of October 4th. I'll close with that. Obviously, this is an issue of deep concern to the town of Plainville and its voters. I'd be happy to answer any questions the commission has.
Anybody? Anybody else?
Mr. Chairman, I'll wrap up. We appreciate again your consideration. I will remind the members of the commission, we have paid $400,000 as an applicant in January. We've gone through this process. We've conducted ourselves in as transparent a means as possible by making this announcement before the election rather than after the election or subsequently. And we are prepared to invest several $100 million here in the Commonwealth, and we only hope that we'll have the opportunity to do so, or at least to be considered to do so. So thank you very much.
Thank you all.
I have a
Oh,
question.
sorry, yeah.
Thank you. Could you take us through the future after, say, next Tuesday? Who runs Plainville? Plain Ridge Racecourse, please. What does the agreement provide for?
As we indicated, we will apply for race dates and to conduct racing operations for 2014 through an operating agreement. We will oversee the operations, but don't envision any personnel changes with respect to the day-to-day operations of the racing activities for calendar 2014. We will also, if able, submit an application, a Phase 2 application on October 4th, and continue to work with the design team on the project that has been presented to the community of Plainville to develop it as the process before this commission unfolds. If we are fortunate enough to be selected to do that, we would designate a general manager who would oversee the operations of that facility while the construction development were overseen by our corporate staff.
Thank you.
And who paid?
Yeah, if I may, my counsel has pointed out, for purposes of consideration by this commission, none of the existing shareholders of Our Way will have any role whatsoever, either in racing operations, any further development of a gaming facility, and clearly not in the day-to-day operations of a slot facility at that location, again, if we're fortunate enough to be selected.
Okay, thank you.
You know, just for the record on that, speaking as a racing commissioner, one of the problems in the previous applicant was the complete absence and failure of administrative systems of accountability and transparency and record keeping and so on and so forth in the existing operations, which inspired little confidence in us going forward. But if you're going to be now, you're responsible for running this track for the foreseeable future or for some period of time. We hope you will pay attention to the mechanisms and the systems in place. You know, Mr. Grogan, who I don't know whether he's going to be involved or not, but he said he had started to implement a whole bunch of procedures. I hope such things will be happening because the racetrack, as long as it's operating as a racetrack, needs to operate in an appropriate way.
And rest assured, Mr. Chairman, it will.
Okay.
It will. I mean, we will have the internal audit, we will have the compliance functions, we will have the managerial and the financial oversights on the operating performance of this facility from January 1st forward under any means, whether it's racing, gaming, or whatever.
And who's running it between now and January 1st?
The existing operator, because I will remind the commission, this is an
It's
option.
an option, okay. Okay.
I didn't
sorry.
have any questions until you said that Arway would have no role in the operation of the track. But Arway does have an income stream for under this option agreement for a period of time after the option is exercised. Isn't that right?
There is a earnout, a payout over time
Over
to the
4 quarters.
only to the existing approved principals. Those principals that are found suitable to realize that revenue stream, and it is only for a finite period of time. That's correct.
So there would be, as part of the Penn suitability process, an examination of the suitability of those individuals to receive the payments. Is that right?
That's correct.
And that is part of the package that the IEB is now exploring, is it?
That is my understanding. That's correct, yes.
Okay.
That would be part of the suitability review of us as an applicant, and certainly a review by this commission of our application, including the Phase 2 application. We did not believe that that was an issue for today's discussion.
No, I understand that, but the operating piece was something you injected, and I just wanted to...
And again, to be clear, in response to the day-to-day operations, no
I understand.
involvement whatsoever by any of the existing stakeholders.
I understand
Who is committed to paying the town the cost of the election?
That is included in the host community agreement, and again, as this commission knows, we have accepted, we've sought and have received the consent of the community to be the assignee of that host community agreement, so we are the successor in all ways to those responsibilities under the host community agreement.
Can I speak to that, only because I don't think Steve is
Pull the
aware.
mic over.
Notwithstanding the requirement.
Introduce
I'm
yourself.
sorry, Joseph Fernandez, Town Administrator for the Town of Plainville. Notwithstanding the fact that the legislation anticipates that the applicant, and I didn't go to law school, so I'm not sure how to define "the" any more than I was, the term "is" when it was used a few years ago as to what it meant. Nevertheless, our way, in a dispute with, this goes back 3 years ago, a dispute with an abutter, requested a number of documents, and it would have required a great deal of time and effort. They placed a $10,000 deposit to pay for the costs, and I was reminded a couple of weeks back they never get their balance back. So there is $7,700 on account with the town that will cover the cost of the election, even though they are obligated to pay whoever the applicant may be.
All right, whatever. I mean, if you're committed, you work it out however you work it out.
We have rights and we have responsibilities under the host community agreement, and the cost of the election is one of those
All right,
responsibilities.
that's fine. Anything else?
Quick question for either Mr. Fernandez and Mr. Silverstein. Can you just kind of quickly walk through the interaction that the Board of Selectmen has had with Penn National? One of the comments raised that we received reflected on the issue of notice of the hearings, notice of any discussions or votes that the Board of Selectmen took, but if you could just walk me through and make sure that obviously all local and state laws were abided by.
I'm not sure exactly what the reference to in terms of notice is. If we're talking about the very structured notice requirements for public meeting, working backwards, the Board of Selectmen voted to assign, consent to the assignment of the host community this past Tuesday. That meeting was posted the previous Thursday, counting Friday and the balance of Tuesday as the 48 hours. So if that's the question, obviously the holiday didn't count and was not anticipated to be counted. Is that your question, Mr. Commissioner?
I think that adequately addresses the comment.
I mean, I can speak to the amount of outreach there's been and the number of public meetings and forums, if that was the purpose of the question.
No. Thank you.
Anything else? Thank you, folks. Did you have more besides, until we get to the other speakers?
I do not.
Okay. What else is on your agenda once we finish with Penn?
I have to report back on the matter between Boston and
Right.
the wind
And
development.
and that's it?
And then we have some questions related to the
Okay.
application that resulted from our pre-application meetings with Category 2.
So we may hold this meeting open until Saturday.
I'll be brief, Mr. Chairman.
Okay. We invited people to speak. They did via the website, which you've now heard about. We invited people to speak in person. We said that we would have only representatives of organizations because we couldn't have many people be here all night. We have 4 organizations, representative people, which I will invite up to speak. We have 4 people who have identified themselves as Plainville residents, not representing an organization. I'm sort of half inclined, given that they've come a long ways, and we don't have a huge number of people, to give them an opportunity to speak briefly, if they're going to speak only to the point. But on the other hand, we said we wouldn't have speakers, and so we just wanted a sense from other people whether we should invite these folks to speak or not.
I'm perfectly happy to have them speak. We're always receptive to and do read thoroughly all written comments that we receive too. So if they've sent us something in writing, we've already read it. But if they haven't, and there are others who haven't come because they thought they couldn't speak and want to write us, we'll read that too and take it into full account as we proceed, regardless of what the decision is today. There's much more to this process than today.
Right.
Correct.
Anybody else have?
I would be fine with that, too.
No objection.
Okay. All right, so let's start out with the representatives of organizations. I'm just going to take on the list in the order that they appeared on the list. Marianne Grenier from the No Plainville Racino organization. Yes, please. We'll be flexible on the time. It's meant to be 5 minutes or so.
Yes.
Remember that your remarks are targeted at the specific issue to the maximum extent possible.
Yes. Commissioners and Chairman Crosby, thank you so much for allowing these comments. Your actions actually inspire confidence in the process, and I thank you for that. I'm here today representing an organization called No Plainville Racino. We're an organization of about 75 people, the majority of whom are from Plainville, although we also have folks from Rentham, North Attleboro, and Foxborough who are active. Today, we are registered as a PAC with the town, just as a disclosure. We respectfully urge you to find that Penn National Gaming is not and cannot be the applicant referred to in the host community agreement being voted on in Plainville on September 10th. On the long journey toward expanded gambling in Massachusetts, we have been assured that the law was written with certain checks and balances to protect the public. The requirement of a minimum of 60 days for the public to inspect and inquire about the host community agreement, which we have had the chance to do, and about the parties who signed that agreement who might well be licensed to run a gambling facility in our town, should be kept sacrosanct. According to the August 29, 2013 applicant status report on your website, Plainridge Racecourse Our Way Realty LLC is listed as the applicant for the Plainville host community, signed the host community agreement, and is listed under the host community referendum, HCR. The applicant for the HCA and HCR is clearly Plainridge Racecourse Our Way Realty. Penn National Gaming, on the other hand, is listed as TBD for host community, with an NA for host community agreement and an NA for host community referendum. I understand that this is what was attempted to be changed last Tuesday at the Selectmen's meeting. However, this is what appears right now. As you discussed at your last meeting, Chapter 23K, Section 15 states, and I don't need to read it, you know what it says. I'll forego that if that's okay. What it states leads me to believe that Penn National Gaming, while they would like to be an applicant, that they would need to enter into an HCA with Plainville themselves. Another election would have to be held in 60 to 90 days. This would put the election after the October 4th Phase 2 deadline, however, and of course not within the time frame to apply for a Class 2 license. There is no way that we want the election to be stopped or to in any way impinge on what the voters can vote. However, we do believe that there currently is no eligible applicant to carry forth with the host community agreement. From the host community agreement, it is clear that Plainridge Hourway is the applicant of record with the project. As I listened to the arguments by Plainville Town Council and Penn National's lawyer to allow Penn to be considered the applicant, I was reminded of an article I read recently about Penn National's proposed spin-off, in which the casino regulators in Ohio called their separation plan legal fiction. The very idea that Penn could be the applicant of Plainridge also borders on legal fiction, I believe, not only because of the requirement that the applicant sign the HCA 60 days before a vote, but because many statements written to refer to Plainridge and the HCA clearly do not truthfully represent Penn National as Plainridge. One of these is that Plainridge has run the race course for 15 years, and I believe in reading deeper in that, it means that the people who formerly ran the race course or formerly were the applicant. That's who Plainridge is referring to. It's not referring to Penn National. So rather than having what we know to be truthful in the HCA represented, there are ghostly impressions left in the wake of the disqualified applicant. The HCA agreement as written is no longer accurate and true. At your meeting on Wednesday, Penn National Gaming stated multiple times that the HCA was transferred from Plainridge Hourway to Penn National Gaming in a unanimous vote. The reason this was unanimous was because the HCA required the Plainville Selectmen to do so, with the HCA stating Plainridge shall not transfer or assign its rights or obligations under this agreement without prior written authorization of the town, which will not unreasonably be withheld, delayed, or conditioned. While many of us would have had the Selectmen take more time to consider the details of that proposition, they had only just met the Penn National representatives at that meeting. Perhaps even bringing the transfer to the people of Plainville before their unanimous vote, it's not surprising that they signed with very few questions asked. In the Gaming Act, it states that a Category 2 license and the host community agreement it would inherit is only transferable upon a change in ownership. I would maintain that an option to purchase Plainridge Hourway is not a change in ownership and therefore should not be considered as a reason to allow the transfer of the HCA. Penn National's risks in this deal are minimal. While Plainridge spent over 15 years and millions of dollars building their facility and being a part of the community, Penn National Gaming has only invested $100 in their conditional relationship with Plainridge. Penn National Gaming has not expended large amounts of capital nor invested in the town of Plainville. They are taking no chances and minimizing their risk. One of the Selectmen's perennial selling points for slots at Plainridge was that we knew the operators, had known them for 15 years, knew that they were devoted to the town, and that we could trust them. As it turned out, we couldn't. Still, to rush to partner with another unknown developer from another state, especially one working on their third attempt for a license in Massachusetts, seems counter to everything the Selectmen have assured us about accepting expanded gambling at Plainridge. The Selectmen met the representatives from Penn National for the first time on Tuesday night when they signed the agreement to transfer the HCA, and now they want to give us less than a week to decide how we'll vote. Finally, Penn National and the Selectmen seem to believe that a few days is plenty of time for the people of Plainville to discover and digest information about PNG and to react and respond to the change. While the various applicants for a gaming license are flush with disposable income for public relations, polls, signs, mailings, etc., the residents in the towns where gambling facilities are proposed are often forced to scrape together private funds just to buy a few signs and print a few flyers. It's, I believe, a blind spot in the legislation that leaves the public, in particular any opposition, at a distinct disadvantage. So, by necessity, we communicate door to door, neighbor to neighbor. That takes time, certainly more time than a few days immediately after Labor Day might provide, with people returning from their summer holiday and school just beginning. 1 week between the introduction of a new acting owner and a referendum is simply unacceptable. Not only do we deserve time to contemplate a change of this magnitude, but the Gaming Act of the Commonwealth, we believe, gives us the right not to be rushed into a decision. I urge you most respectfully to uphold those laws and deny Penn National's bid to become the applicant for slots at Plainridge. Thank you.
Thank you.
Thank you.
Any questions?
I thought I heard you refer to a provision of the host community agreement that said that there couldn't be a transfer unless there was a change of ownership. Would you, did I hear you
No,
correctly?
what I was referring to was the provision that the selectmen would have to
Approve the change of ownership.
Is that the one, was that where I,
Section 8. All right, if I misunderstood you, that's fine.
Okay.
I just was confused, so thank you very much.
You were referring to the section that says that the HCA rights and obligations can be transferred, but only with the approval of the town, which cannot be unreasonably withheld.
yes,
Yeah, okay, thank you.
thank you very much.
Mr. Abdelnour, couldn't read the handwriting, I'm sorry. From the NEAHDC, you'll introduce yourself. Thank you.
Thank you. My name is Bill Abdelnour. I'm the president of the New England Amateur Harness Drivers Club, thus NEAHDC for short. We're located in Plainville. We're a 501c3, not-for-profit, recognized by the state and the federal government. We race horses there at Plain Ridge Racecourse. It's the only place we've ever raced. And we participate quite often in various events with Plainville and the town of Plainville. We donate money to certain things. Being a nonprofit organization, as you well know, we donate all our money to charity and various events in the town of Plainville. They're a terrific partner. They're wonderful people. They're caring. They deserve to have this vote. They deserve some strong consideration on this application. I'd like to just mention one other thing about Penn National. We had a forum last night. Second time that I met this group behind me. Wonderful people, first-class operation, traded publicly, NASDAQ, in 18 states, 28 or so facilities, gaming/racing. That's their business. They're not a rogue company that just decided, hey, let's apply, throw up $400,000 and try to get an application for a slot parlor. This is a game changer for the town of Plainville, who so deserves it, a game changer for harness racing. Your own words, Mr. Chairman, you promised that you were going to do everything you could to help racing, thoroughbred harness racing in Massachusetts. This is a golden opportunity. These people are first-class people. I'd like to just finish by telling you, I'd like to make somewhat of an analogy. I thought about this a lot. I'm a big sports fan. In sports, a player that comes in and makes a difference changes the whole complexion of the team. People like, makes them winners. Larry Bird, Bobby Orr, Jim Rice, Freddie Lynn, Bill Russell. They all came in and became impact players. Our impact player and the town of Plainville's impact player is Penn National. They're going to change everything. The town will become more prosperous. They'll save jobs as well as create them. They'll save an industry that's been in business for over 200 years, that's not far from going the way of the dinosaur. They're an impact player, and we need them. Harness racing needs them. Plainville, the town, needs them. The state of Massachusetts needs them. So I hope you really consider this transfer and give them a fair shot. Let the people vote on Tuesday. It's just Tuesday, several days away. And I can promise you, they'll be overwhelmingly in support. They can't wait for this company to come in and do their thing because they have a proven track record. They're not rookies. They're not coming off the bench. This team knows what they're doing. I've heard them speak. I've read a lot about them. Very impressive. I hope you really, really consider this transfer and give them a fair shot to save racing, to help Plainville, to keep open space and save harness racing that's been around forever. Thank you.
Thank you. Any questions? Just for the record, this is not a vote on whether they're quality people or not.
Right,
No,
I understand that, but I had to,
I got it.
you know, I had to.
You had to use your sports analogy. I got it. We appreciated it. Thank you. Next on the list was Michael Perpall? From the Horsemen's Association? That's correct. Sorry, I should know that by now.
Gentlemen, thank you for letting me come before you. I am the president of the Horsemen's Association, and I represent about 350 folks that earn most of their income by participating in harness racing at Plain Ridge. One of the main functions of my job in this environment is to make sure that harness racing continues. And as I look at the situation, I say that if Penn National was not approved, we would end up with 3 candidates for the slot parlor. Only one of those candidates would have any interest whatsoever in harness racing, and that would be Mr. Carney. And nothing wrong with Mr. Carney, delighted that he's interested. But that only gives us 1 chance out of 3. If you approve Penn National, we now have 2 chances out of 4. Because these people, they're gonna do racing only if they end up with the slot parlor. If they're not ending up with the slot parlor, they will not perform under anything in 2014. There will be no harness racing in 2014 if they are not awarded it. So that's why I think it's very important to keep 2 players in the game, and at least we have a 50% shot that one of them would be awarded the license.
Well, I misunderstood what Mr. Snyder said then, I think, because I thought I heard him say that Penn National was going to apply for the license, and if granted the license, would...
He was very specific last night at the forum and stated that he would only perform if he was awarded the slot license. And that wouldn't, we would not expect him to perform, because the economics of the sport right now are such that without expanded gaming, particularly where we're competing with expanded gaming all around us, it is virtually impossible to run a successful operation without the additional income from the expanded gaming. And if you've had an opportunity over the last year or so to look at the financial statements of our way, you see what the losses that they sustained, and it was principally from the horse racing.
Could you clarify what you were?
Well, I heard what he said, but
Do you want to, Mr. Snyder, do you want to clarify? Was there a misunderstanding here? Do you want to, Jim, ask again?
Yes, Mr. Snyder, if I might, I may have misunderstood what you said, but I thought in response to one of the questions that one of my colleagues asked, you said that Penn National was going to apply for the license for 2014.
For the conduct of live racing and simulcast and other racing operations
That's right.
at the racetrack, yes.
At the racetrack.
Correct.
And if awarded that license,
The racing license.
the racing license now,
No, I did say that we would apply for it. I wasn't presumptuous that we would be awarded,
no,
but
okay, then let me ask you to be presumptuous in a hypothetical sense. If you're awarded the license,
The racing license.
the racing
Not the
license,
gaming license.
The racing license. All of my remarks are directed solely to the racing license. Is it Penn National's intention to run live racing at Plain Ridge, whether or not they receive the gaming license, if they're awarded the racing license?
we've only made the determination at this point in time that if we are awarded the gaming license, we would continue 12 months of operations in 2014.
And if you're not awarded the gaming license, have you made representations one way or the other?
We have not. The representations that we have made have been that we will apply for the racing license for 2014 to conduct operations consistent with historical fashions. We've also made it clear that the only long-term viability for this industry is to have supplemental income in the form of slots. We have not drawn a conclusion at this point in time We have not found a way, quite frankly, based on our experience in many other jurisdictions, to make harness racing profitable without the subsidies that do come from slots operations at similar type facilities.
Okay,
Okay.
thank you. Thank you, Mr. Perpall.
Thank you.
You're welcome.
And then Ms. Grace Lee, Attorney Grace Lee, on behalf of Raynham Park LLC.
Morning, Commissioners. Good morning, Chairman
Morning.
Crosby.
Actually, good afternoon.
It is afternoon. And I'm on behalf of Raynham Park LLC. Hate for people to think that I am an entity in and of myself, although sometimes I think I am. Or at least my husband does. I'll try to be brief, and I want to thank you for the time. We are responding to your request for input on the transfer of the host community agreement from our way over to Penn National. I think, and I don't know if you've had an opportunity to review my written submission on behalf of Raynham Park LLC, so I'll try not to be redundant. Thank you. So, and if I'm being redundant, please feel free to tell me to stop. There's a couple of things I wanted to point out and kind of addressing why I'm here before you on behalf of Raynham Park LLC. Fundamentally, I come before you for two reasons. I think the statute, the expanded gaming statute, Chapter 23K, prohibits this. It didn't contemplate it. These type of transfers are frowned upon in this industry as it relates to licensures. And more important and fundamentally, this is a matter of fairness and process. And as you know, Raynham Park LLC has been very, very appreciative of this commission's process, the integrity and the transparency in which this entire application process is kind of organized, and the process we've gone through has been very, very comforting, and we've all enjoyed a great deal of confidence. And, you know, at times, process has been very demanding, arduous, and very fast-paced, but we've always been comforted with, you know, the concept of transparency and fairness, recognizing that everyone had to play by the same rules. Everyone's under the same amount and same level of scrutiny, the same type of deadlines, and the same standards, and most importantly, the same legal requirements. So I submit to you, you know, those are the factors that I would ask that you contemplate, not just the isolated, you know, the isolated question of whether the host community agreement is transferable, because nothing, and most definitely the statute, does not operate in a vacuum. And I'll deal with the definition of the applicant. There's some points that counsel for Penn brought up as to the language of the statute, and I believe it is quite unambiguous. It's the applicant. The reason why process and procedures are in place is because the statute anticipates there is one applicant, there's one dance partner, so to speak, because the process is to ensure that the partnership of a community and the applicant, not any applicant, has the appropriate amount of time. And in looking at that, I think that it's important to recognize throughout the statute, as well as within the regulatory scheme that this commission has put out, there's safeguards, there's consistent safeguards, and I would submit to you as a matter of law that this commission should not and cannot grant the authority for the transfer because they cannot satisfy the statutory requirements. Case in point, under 16, that's 205 CMR, oh gosh, 115.05, I believe it's 6B. or 6, excuse me. It's, what we've been referring to as the procedure for prior to this commission finding suitability. There is a process for a community to go through before they can hold a referendum. And significantly in that, it also has the language contained in there, the applicant, and it specifically says, and I'm not talking about the applicant right now, I'm talking about the governing body. The governing body, before the applicant that has submitted its application to the commission and is courting that particular community, before that applicant can go on the referendum, there needs to be a positive determination of suitability. There's that. However, this commission in its wisdom said, we're gonna give you exceptions to that. In the event that prior to any determination, the community wants to hold a referendum, you all let everybody do that. And you did that by saying that the governing body, in this particular case, it would be Plainridge, the Board of Selectmen have to formally agree. They need to vote that they're going to allow a referendum on this issue to have a gaming establishment in that community, right, prior to that applicant being found to be suitable. That is very specific. And if you look at that, it's the applicant. And the reason why the applicant is important is because before a determination is made, there is a notice provision that is given to the community. The commission hasn't vetted this particular candidate, but you know what? We're going to give you 60 days. And you can do your due diligence. You guys can look. You guys, and there's, I'm sure, as you all know, there's, a lot of campaigning going on, but there's always that opportunity for the voters to vet the candidate, the applicant, prior to that referendum. And Plainville did that on July 18th. They voted, and I wasn't at the meeting, and I don't have the transcripts, but I've got to think that when they passed that vote to put that referendum on the ballot this coming Tuesday, it was one with the expectation that it was prior to a suitability determination, and two, it was as it relates to our way, the applicant. Now, I'm sure our way wishes that the suitability determination hadn't come out the way it did, but the applicant they voted on to allow to be on the ballot was our way. So satisfy that. Unfortunately, our way was found unsuitable. I think at this point, the analysis ends, because that is the entity, that is the applicant that the governing body put forth. Now, understanding above and beyond that we're talking about transferability, notwithstanding the fact that Penn is saying they're stepping in the shoes of our way, they are not stepping in the shoes of our way. This is something other than that. There is some kind of financial ongoing transaction. It's contained in 4.2, I believe, of the purchase agreement, as well as the calculations contained in their Exhibit D. So, as a matter of law, if you have it's under the statute, I won't bore you with reading it, although I did provide it in my written submissions, and I did intend to read it actually, but I will save you from that. But as this commission knows, if you have a financial interest, you are a qualifier.
Well, why isn't that for the qualification piece?
Because this commission has said our way is unsuitable and cannot go forward to phase 2 of the process.
Well, so if our way is included as a qualifier, and the representation a minute ago was that our way is not the recipient of the payments that certain individual participants in our way may be. But in either event, if our way or the participants are found to be unsuitable, why can't, in the suitability piece of our work, the commission say that? You can go forward, Penn, but you can't go forward if our way other people, any of your officers or directors are found to be unsuitable. So you either have the choice of being unsuitable and you can't go forward, or you have the choice of jettisoning those people and go forward. Why isn't that the remedy for that problem?
Well, Commissioner McHugh, I would submit to you is that we don't even get that far in the analysis because they haven't satisfied the statutory requirements.
Well, I understand that you've placed a little different weight on the word "the" than your counterparts did. So, but you did raise this piece.
Right.
So
No.
Focusing on this piece, why isn't an amputation of that kind an alternative at the end of the suitability process to deal with that problem?
Because I would submit to you, Commissioner McHugh, that it is intertwined with the notice provision, because if we're going beyond the black letter of the law, then we should most definitely focus on the spirit and intent of the statute. And if we look at the statute and the regulations as it relates to having the referendum and giving the opportunity for the community to review the suitability of the applicant, and if you're going to review the suitability of the applicant, it should be transparent, and especially when you're changing partners like that, that one of the qualifiers which the commission has already found to be unsuitable is financially profiting. That has not been disclosed in the letter to the citizens. That has not been advertised in the summary of any of the information that's been disseminated. So I submit to you, on that level, the suitability determination has its own legal significance. But throughout this process, the suitability, integrity, and character of all the applicants, as well as the organization, that aspect is intertwined through the entire evaluation process. So much so that in the event that the commission has not made a positive determination, the commission wants the voters to know that you have not made a positive determination as to this particular applicant. And I would submit to you, in this particular case, it is so much more important because it's not even the original applicant, it's another applicant with the original applicant.
Well, I really have to challenge that premise. I don't think there's anything before us that says that there is a partnership between Penn National and our way going forward here. We heard representations to the contrary. And in any event, if that is so, I come back to my question, why can't the commission, as part of the suitability process, say that our way is, if it is a qualifier as opposed to individuals, that our way is unsuitable and you can't go forward. And the letter that's been sent to the citizens says that we haven't finished the qualification exam. I think we're conflating two different pieces of this process. Not we are.
I think
you are.
Well, that didn't make me feel so good.
Sorry.
Well, I would submit to you, Judge McHugh, that, understandably, if this commission, allows and grants it, yes, that is the appropriate procedure under the regulations in the process. But as I stand before you today, what I'm explaining in general terms is this goes beyond just the town of Plainville. This goes beyond just the applicant, Penn, the former applicant, our way. This goes to the entire process. This talks about contorting the procedures that have been consistent, that all the other applicants has satisfied to accommodate in the community, because the possibility of disappointment. The bottom line is there are going to be 3 disappointed communities and 3 very disappointed applicants in the end of this particular process. And the only thing that anyone's going to be comforted by is that they had faith in the process. And what I submit to you today is when you deviate from any standards that aren't consistently applied, that indeed will inevitably result. And so I understand that there are many, missions and agendas that this commission has to satisfy, the community outreach, the economic development. But I submit to you the most important is the integrity of the process and the rigid and the faithful compliance with the standards that the Gaming Act has established, as well as the regulations, and how they've been applied in the past. And you heard a lot of testimony about there's been a lot of education in the last few days. That's because they weren't the applicant. The educational process was intended to begin in the beginning of the process, so there was a genuine understanding of the two parties. And so, and this kind of loops back and to my original premise that the suitability aspect of it, the integrity of and the characters of all the parties, is a very important aspect of disclosure when it comes to having someone else step in the shoes, so to speak, which I submit to you, they're not stepping in the shoes. And when that's not disclosed openly and very, very transparently, it leaves a very bad taste in your mouth. So I see that you've tired of me, so I think so I will then thank you very much for your time. And as you know, we submitted something in writing, so this would supplement that. And again, thank you very much.
Thank you.
Any other questions? Thank you.
Thank you.
Okay, there are four people who refer to themselves as Plainville residents. I think the last name is Merrick, Bearquim, Brem, Murphy, I think. If any of you have not submitted written comments, go ahead and identify yourself. And
I haven't.
you haven't.
For the record, Mr. Chairman, my name is Ned Merrick. I am a Plainville resident, former police chief for the town, and very interested in this
And you're welcome to speak to the issue at hand.
Yes, sir. Thank you. Having been a policeman for 40-odd years, I admit to not being totally conversant on all the nuances of both the statute and the CMRs involved in this, but I do understand what is right and what is fair, and I think I recognize that when I see it. And obviously, the ability of the town to vote on Tuesday on the host community agreement that has been proffered, and frankly, I don't care who proffers the agreement, the agreement that's been proffered to the town, we should be allowed to vote on that. I think that's a basic constitutional right of every citizen, and I know that this commission would be more than willing to uphold the democratic process. I admit to being somewhat disappointed when the commission found the former owners of Plain Ridge to be unsuitable, because I saw a very, what I thought was a pretty bright financial future for the town, potentially being flushed down the drain. But since then, the savior has come to Plainville and has changed the landscape.
The impact player, that would be.
The impact player. Right. And I, not being nearly the jock that Billy Abdelnour is, I won't even get into that. But it seems like, at least from my perspective, there has been a tremendous amount of minutia being thrown back and forth to muddy the waters, frankly. My understanding of the way this thing works is that our job in Plainville, as the residents of that town, are to vote up or down on the host community agreement and the siting of a gaming facility in our community. And frankly, I wouldn't care if it was Mickey Mouse that was doing it. If he's going to throw $4 million at the town, I'm in. It's very simple.
I don't think he's an applicant.
I'm not even sure he's suitable.
I don't know.
We never let a mouse get through our background checks.
I'm feeling the heat behind me from Penn National calling him Mickey Mouse, and that's certainly not what I infer. As a matter of fact, I have met several of the players from Penn National in the last several days, and in my business and my former business before I retired, 40 years as a cop, I made a lot of snap decisions, made a lot of snap judgments. Some of them were wrong, most of them were right. And I look these guys in the eye, and I see the same community commitment that I saw with everybody at Plain Ridge since they built the place. I was the sitting chief when they built that racetrack, and I was a strong supporter of the racetrack. I actually got slammed in the paper the other day for being a supporter of the racetrack. They called it a chilling effect, whatever that means. But the notion that this town can go forward financially is what it's all about as far as I'm concerned. And I frankly am not really surprised to see a competitive applicant up here saying that you shouldn't allow this, because frankly, the host community agreement that we have in Plainville kicks their butt. They're not even close. So I would urge you to allow us to continue the democratic process, to unmuddy the waters, if you will, and shake this thing down to what it is. We're voting on a host community agreement and the ability to site a gaming facility in our community. And if you guys want to sit around and argue about the difference between and the, you can have at it. I mean, that's fine. And I think that is, frankly, that is within the purview of this commission, as is the ability to determine whoever the applicant is or whoever the owner of the racetrack is, as far as suitability goes. We trust you guys with that. We have neither the wherewithal nor the ability, or in many instances, not even the willingness to be able to do the kinds of due diligence that you guys have done already. Despite the fact that I was a little disappointed at the decision, you actually did us a favor, because what we've ended up with is even better than we had before. So I would hope that you would vote in favor of allowing the vote to go forward just the way it is. And I stand for any questions that you might have. Thank you very much.
Thank you.
Questions? Thank you, Mr. Merrick.
Thank you.
Dale Bearquim, do you have something to offer that's not been in an email to us?
I submitted an email, so.
Thank you. All right. We appreciate it. Thank you for coming down here. Chris Murphy, do you have a?
I too have submitted an email in writing
Okay.
2 days ago, so you have my thoughts and feelings recorded in writing.
All right, great. Thank you. Thanks for coming. And Mr. Brem?
Unfortunately, I didn't have time for an email.
All right.
My name's Leo Brem, and I'm a resident of Plainville, father of 2, and I'm raising my family in the cute little town that we all know as Plainville. I live a short distance from Plain Ridge, and I pass by it every day on my way to work in the greater Boston area. Like many of the folks who live in Plainville, I commute to the greater Boston area. And I feel as though, like many of those folks who do have families and work, that 10 days wasn't an adequate enough time to vet the new applicant for the Plain Ridge Racino, as it's been named in the town. And I feel that it would be, under the circumstances, that we had put our trust in the previous owner, and when the mismanagement was come to light, it brought a lot of questions to my mind as to perhaps that the racetrack was a little more profitable than we all thought, and could be more sustainable if managed correctly. I do want the best for Plainville, and I echo all the same hopes and dreams that the previous speakers did for Plainville's future. I will not argue the definition of the applicant or a applicant, but I do feel that knowing the applicant effectively and educating the community wholly is takes more than 10 days over a holiday weekend, including yesterday's Rosh Hashanah. And, excuse me, in this very new, as the town council pointed out, new industry to the state of Massachusetts, in particular, little town of Plainville. And I believe everything else that I would say has been said. So thank you for your time and consideration. And I know it's not an easy job, what you're doing. So thank you.
Thank you.
Questions? Thank you very much, and thanks for coming down. Okay. Do you have anything else to add, Ombudsman?
Not on the Plain Ridge discussion, no.
Yeah. So I think we are left to discuss amongst ourselves how we want to go forward on this. And we've decided to do it in the normal course of our regular meeting. Anybody want to start off on where your head is at, the way you see the issues? Well, I will happily jump into this. It does seem to me that the far and away the net of the issue is the reference to the applicant. It seems to me absolutely totally clear that the legislation anticipated that the applicant who signed the HCA would also be the applicant who went forward with the rest of the process. And in that sense, that's what the applicant meant. And in the most literal possible reading of this law, what was supposed to happen didn't happen. That is to say that the applicant, who is today the applicant, had the HCA signed at an appropriate time. I do also think that the 60 days was principally designed to give the community an opportunity to understand what the HCA was about, but it also makes sense that that was another 60 days to get to know the partner. It doesn't make that explicit, but I mean the applicant, not the new applicant. And I think the one argument that troubles me is that I think it is a legitimate point that the new applicant is new to the community. And although nobody anticipated this kind of a situation, yes, the community is being deprived of the opportunity to get to know this applicant like they would have gotten, like they had gotten to know the other, and like they would ordinarily get to know in the course of the 60 to 90, at least 60 to 90 day period. Having said all that, I think there are a host of considerations on the other side, and I think that the switch of applicants and getting to know Penn there are a number of bites at that apple that are going to be available to the people of Plainville between now and the time the licensing decisions are made. There has been some degree of consideration already. Elected selectmen voted to transfer this ownership. Those people will be up for election in due time. There is a recourse if this was a bad judgment. There will be background checks done by us. We found the problem with the last applicant, and as has been said, we are being relied on to make the judgment about this applicant. There will be a tremendous amount of information that will be available to the people of Plainville about the new applicant. There will be public hearings, 2 of them, one that was informal, one that's legislatively mandated, on the applications, where we will be inviting the people of Plainville as well as others to talk to us about what they think of this application after they have had much more time to get to know the new applicant. So there is an opportunity for a remedy of this modest downside of the change. And with that opportunity to remedy, it seems to me that if we were to kick out this applicant based on the technicality, but a meaningful technicality, that it was meant to be the same applicant, the loss would vastly outweigh the gain of that modest remedy. The loss of the competition, the powerful statement we have to ascribe, the legislature wants us to ascribe tremendous consideration to the elected authorities in the local town. They have clearly and emphatically said how they want us to go on this. We are deferential to those judgments, and the people of Plainville have an opportunity to fix that if they don't like it. So when all is said and done, I think there is a fair point. I think it's been articulately spoken to. I think Ms. Grenier made the point. I think Ms. Lee made the point. It is not an irrelevant point, but our job is to net these things out as the facts unfold, as we understand the intent of the law, and my predisposition at this point would be, therefore, to go ahead and grant the transfer.
I reach essentially the same conclusion, although taking a slightly different route. At the outset, I think it is important to think about and recognize the integrity of the process. Ms. Lee's point in that regard was very well taken. I think that the part about the qualifiers who we have found to be unqualified will require careful examination during the qualification process to see exactly what that arrangement is, and the Commission will do that. There are a number of points that lead me to the conclusion that's similar to the one that the Chairman just stated. First of all, this is an applicant which met the January 15 deadline. And in the exercise of our discretion, we did not require the applicants for Phase 1 to signify a site. So in fact, a number of them didn't. At the time the applications were filed, they had no site. So they met that requirement. Our Way and Plainville executed a host community agreement. That host community agreement, the terms of it, have been before the town for more than 60 days now, or will have been by the time of the election. And nothing in the summary that's on the ballot and nothing about the terms of the agreement has been challenged, and those terms are not changing. One of those terms was that the agreement could be assigned if the Board of Select Board agreed to allow it to be assigned, and the Select Board has allowed it to be assigned. There's nothing wrong with that as a matter of contract law. It may be a reason, the assignment may be a reason to vote against the host community agreement when it comes before the voters, but there's nothing wrong with the assignment as a matter of contract law. And Chapter 23K is explicit about the ability to transfer rights under the license with the Commission's approval after a license is awarded, and indeed after the vote is taken without going back and having the voters vote again. So in terms of the legislative intent, that leads me to think that the legislature put greater weight on voter approval of the terms of the agreement than it did on the precise identity of the person who was going to fulfill those terms and give benefits to the town. It left that part to the Commission and to those who were, primarily to those who were signing the agreement. And so the question comes down to whether or not there's a public policy that overrides the contract law that otherwise would make this a perfectly valid transfer. There is the statutory vote is to decide whether there should be a casino located at a specific location. That's the specific terms of the vote that's required by statute, not whether a specific casino run by a specific person or entity should be at a specific location, but whether there should be a casino at a specific location. There's a requirement that the host community agreement be summarized on the ballot, not that the identity of the entity that has signed the agreement be summarized, or that its background be summarized on the ballot. As I've said, the transfer could occur immediately after the vote were taken without another vote, and it's logical that another vote isn't required on suitability because the Commission is charged with determining suitability. So when I put together all of those things, it seems to me that while a change of ownership may be a reason for a negative vote, it's not a reason to prevent a vote. It complies with the literal terms of the statute. It complies, so far as I can determine, with the intent of the statute, and there is no public policy that suggests that shouldn't be allowed.
I agree with both of you for all those reasons that you articulate well. The only thing that I will add is that in our past we have been deferential to the general issue of local control, and it occurs to me that is fundamentally one of local control at this particular juncture, with the Board of Selectmen having approved this assignment of the host community agreement. And of course, ultimately, the voters deciding on Tuesday. So I am also persuaded by the arguments towards the assignability and transferability of the gaming license once it's awarded, and that the statute and our regulations couldn't have contemplated and did not contemplate the time before. But the fact that they have not been explicit about that should not be a point to prevent it, in my opinion. But I think you articulate all the points well, and I'm in agreement with this.
Commissioner?
I echo what the three of you have already said, and I'll place a little bit more of an emphasis on our experience in kind of tapping into areas where, you know, the host community felt they should somewhat prevail. As we remember, again, confronted with a situation that the legislation did not anticipate. We had I know the Penn National people are familiar with the situation in Springfield. But our interaction with the community and, you know, feedback from members of the legislature that really wanted to remind us that this portion of the process is heavily dictated by the community and the community leaders who have the authority to, one, negotiate such an agreement, two, to put such an issue on the ballot, and to make sure all the local standards and obligations are met. You know, as Commissioner McHugh pointed out, they have been an applicant since our original deadline on back in January. You know, even since our decision not to find our way suitable, the local authorities did not ask that the day of the vote be canceled. They did not ask that the election not go forward. My guess or my expectation is that they were, you know, hopefully expecting to be approached by another suitor. In this case, they were. Their host community agreement, and we have always had, I feel, a position of not trying to even intrude on the components of a host community agreement. You know, the provision which allowed for the transfer, which from everything we know is appropriately requested and it was appropriately approved and transferred to Penn National. I don't see anything that would not suggest that the election should not go forward. As we've talked about, there are other bites at the apple. The public hearings that we will be holding, where Plainville residents, obviously, and the other residents from neighboring towns will have the opportunity to convey to us whether they feel that Penn National has stepped up, become potentially a good community partner, as well as express any other concerns or frustrations that they see with the final detailed plans that Penn National will plan to put forward. But you know, we still have our suitability investigation, and ultimately the decision at the end of the day will be ours with respect to the award of the license. But you know, I would say if there's anything, you know, Penn National finds itself in a tough position because there may be people out there who are residents of Plainville that were willing to support this that may not choose to, only because they don't know who the new applicant is. So in some respects, stepping in at this late hour is a detriment to their moving forward in the process. But I don't see any reason that we couldn't allow this vote to go forward and allow the approval of the transfer.
Okay, we will vote on this, right? Do you want to frame a motion?
I move that the commission, without prejudice to any of its rights, responsibilities, or obligations during the course of the suitability investigation, approve the substitution of Penn National for Our Way Racing as the responsible party under the host community agreement, which is to be voted on by the town of Plainville on September 10, 2013.
Second.
Any more discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. Let's take a very short break and come back and we'll pick up the Boston win update. Ombudsman Ziemba, have you you've got something for us?
Yes, Mr. Chairman, I'm very pleased to provide a report that has been provided. It is a joint statement between both the Wind Development Team and the City of Boston.
Yeah, thank you. The Ombudsman just gave me this. This, as he said, is a joint statement from both Boston and the Wind team. Based on the new information provided at Wednesday's public meeting, the parties have agreed to begin discussions about Boston's status as a surrounding community to address the impacts that Wind's proposed gaming establishment would have on Boston generally and on the Charlestown community specifically. And therefore, no adjudicatory hearing of the Massachusetts Gaming Commission is necessary on the question of whether Boston is a host community. That's great. I'm delighted. You know, I'm pleased that they were able to get together and agree to this. And as far as I'm concerned, we move on to other topics. And
Yes, it's a excellent resolution. So, well, I think we're all delighted that occurred.
And
We are, and I want to commend John
That's just what I was
Ziemba
gonna
for the
say.
hard work, and you know, the rest of the team as well, because there's a lot of work that goes
yeah.
back and forth up to these kinds of situations. So thank you.
I think all the credit is due to the two parties that have begun these very worthwhile discussions on surrounding community status, and I commend the teams for getting together and having a very fruitful discussion today.
We may change your title from ombudsman to ambassador.
Right.
We won't do that quite yet.
We got a little
Game
problem
changer.
over in Syria you might want to try to help out with.
Again,
Okay.
I take no credit.
All right, what else is on your agenda?
I'm sorry for belatedly bringing this to the Commission's attention, but over the last couple of weeks, we've been having meetings with with all of the Category 2 applicants. These are the pre-application meetings that the Commission ordered some time ago, where we went over all of the aspects of the application, went over what is expected of each of the applicants, and fielded a number of questions. So in relation to that, there are a number of questions that perhaps might rise to level of policy questions that could be considered by the Commission. In addition, in your packet, what you have is a review that was done by by Pink & Co. of our application. What we did is we asked them to take a look at our application and to see if there is any need for refinement so that the answers that we get to the questions on our application can be evaluated on an apples-to-apples basis. Over the course of a couple weeks, Pink & Co. put together what we see here, and there's a number of different refinements that we could potentially consider. So I'm not asking that we go over each individual item. The Pink & Co. is here to give you a little bit of a flavor of what they looked at if you would like them to do so. What I'm asking for consideration today is what should we do about these further refinements now that we are basically 1 month away from the application date for the Category 2 applicants. As we see it, there are a couple of different ways that we could take a look at this report.
Do we have this, John?
Yeah.
Yeah, it's included in your package.
This is it?
Yes. See,
It's not the,
yes.
just a one-page?
No, it's 2 pages.
You're looking at the second page.
I only have one page, that's the problem, okay.
You want mine one?
Well, I'll share with you. Okay, sorry.
So there are a number of questions in here where we could potentially refine our application. So essentially, I think that there are a couple of different options, or a few different options that we could consider. We could consider reviewing the materials that have been recommended by the Pink & Co. as a staff, and then issue an addendum to our application or an add-on to our application to provide further detail about the specificity that we would like. We could perhaps just as easily ask these same questions after the applications have been submitted, to the degree that the applicants have not provided the specificity that we're looking for. We could go back to them when we ask the further questions of each one of the applications. Or we could just as well, we could leave the application as it is, and leave this for consideration to the Category 1 application for December and any further refinements. You'll see from the flavor of what the Pink & Co. put together, there are a lot of refinements that might make it a little bit easier for the reviewers, such as we ask in general narrative form about the number of employees that are projected. They recommend things such as, well, we should specify that each of the applicants should tell us whether or not those are FTEs or part-time employees. Potentially each one of these applicants might already include a lot of that detail in our applications, and especially after they see the questions today in our packet, they might just try to address these questions on their own. So maybe just by including this as an item for consideration, that they'll do some further thinking when they're putting together their narrative. But if you'd like, I could have the representative from Pink & Co. give you a flavor of what their apples-to-apples comparison looked like.
Well, I guess we haven't really had a chance to read them, right? I haven't.
I did.
Okay.
Yeah.
Do we?
Could I just ask a structural question before we get into substance?
Yes.
We have 2 pages of a document entitled Comments on RFA2 application for Category 1 or 2 licenses. That's in the format here.
That's right.
And then there's a document that I have at least called Summary of RFA2 Application, and it has sections that parallel the sections of the application,
Yeah.
but doesn't list every element of the sections. What is that document?
So instead of including in your packet the 239 pages of our
Right.
application, we just, for summary form, we meant to just give you this summary document that was compiled by.
Yes, the licensing compiled that as they're doing their work to get prepared for the process, and it's a summary document just to provide a reference tool for the questions that are asked by.
So this is not meant as.
So that's keyed to, this document, the summary of RFA2 application is keyed to the pink questions?
So the summary document that you have in here is just for your reference. So we're making obviously no changes whatsoever to the application questions, but instead of including the 239 pages of the application in your packet, we gave you the summary that was put together by the licensing folks so that you could see the actual questions that we have in our application.
So, but it is all of the it's all of the questions.
It's all the questions without the
Yeah,
boxes.
it's just, it's
Without
all of
the
the
boxes
questions,
and
just
the
without the
attachments.
boxes.
Oh, I see.
It's essentially
Okay,
all of our
okay,
criteria.
okay, okay.
boxes, yeah.
We're just trying to say
Yeah, just sort of slowing the uptake.
No, I was too. I mean, it's
The
just
Monarch
confusing,
notes
right.
version.
Right, thank you. That's very helpful, thanks.
Okay.
Well,
Now-
I have another slight structural comment, and I'm ready to get into at least a couple of substance questions. But I think that we should, to the extent that we can, issue additional advisories to communities, or bulletins, to applicants rather than communities, whenever we correct, refine, edit any of the questions that
Yeah.
are in our application.
The only problem, I agree, if we've agreed that we want to do this, as long as we don't think it's inappropriate in any other way to be modifying at a relatively late date our evaluation form, which is a question. But if we find that it is not a problem to modify it at a late date, then we absolutely, I think, should be proactive and send them out. But this, as far as I know, is just the Pink & Company's reading of it, and we spent months, coming up with these questions, and before I would want them to go out as amendments, assuming we think we can send them out as amendments, I would want us to have the time to think about them.
Yeah, and staff has not fully reviewed all of the recommendations as well. But given that our next meeting isn't for a couple of weeks. I thought that we should at least have the discussion of what do we do about this.
But that leaves the category 2 applicants with 14 days or whatever, you know, to adjust their proposals
Right.
to accommodate our late in the game, you know, evaluation criteria, which doesn't seem very fair to me.
Could we do structurally, could we do a straddle, and that is leave the category 2 application as it is, and if some of these are particularly critical and we don't get the answers, seek additional information as we process their application in a transparent and public way, and then issue for the RFA, for the category 1 licenses, some kind of a supplementary or a supplement to the application.
Yes,
Is that a
that is
possible-
one of the options.
Right.
Yep.
Yeah, that makes sense to me. If relative to category 2, we do this orally or subsequent to the applications come in. And I think we don't want, it's not, I don't think we should be asking people to amend now because we don't know whether these are gonna be changes we wanna make. So I don't think our bidders for slots for the category 2 should go off and adjust to this, because we haven't decided that these adjustments are gonna get made. If relative to them, we wanna follow up pursuant to this, we'll do it post-application, but for category 1, we will have had time to review these, and we might come, you know, October, send out some evaluation modifications for the category 2 licenses. Does that reiterate what you said?
Yeah.
Okay, good. Thanks, I just wanted to waste some more time.
Well, well, the most substantive comment that I had.
Larry, could you come up? Because I would be interested in just generically, sort of a sense here, what you guys think you came up with. Excuse me, I didn't mean to interrupt you.
That's right. Well, I did want to mention the one substantive comment that I had relative to one of the recommendations here is to leave the question as it stands. In other words, not to take the recommended comment. And I'm specifically talking about which is what conforms with what you just said, by the way. There's a question relative to revenue generation, and you're suggesting that we assume a start date.
Which question are you talking about?
I'm talking about 210, 218.
218, not on yours.
You were suggesting that we assume a start date of January 1st of 2016 with best, average, and worst case scenarios, I suspect for apples to apples comparisons.
Right, that's the
And,
motivation.
Well, the thing is, it occurs to me that different applicants will have a different projected start, which by itself may have on a net present value, a financial benefit. So I would be of the mind of leaving it the way it is, in other words, unspecified, and allow the applicants to tell us when exactly they plan on generating revenues because of however facing construction timeline, etc. they may have, because all of this is very site specific. If we were to try to shoehorn everybody on a start date, we may miss some of that net present value differential. So I understand the purpose, but I think that given that these projects are fundamentally different, that we just leave the question as it is, tell us when you expect to start generating revenues, and when we analyze them and discount them to today, we can get a financial net present value.
So my comment is that's an excellent point, which speaks to what I would say in summary, which is that I agree with what Commissioner McHugh and Commissioner Crosby said, that staff and the commissioner should should respond to what we said with all of the information that you have,
right.
And that by the time that happens for the Category 2 applications, if any of these things do seem like they have some substance to them, we can do that after the applications have been submitted, and we have plenty of time to make this a formal amendment for the Category 1. That makes sense to us as well. I would also just say, I think, as a matter of record, that none of these really seemed that substantive. Our review of the application is that it's a terrific application. I mean, I think when you go through that, you're going to see that most of these are pretty lightweight.
Okay. They may be valuable.
Well, they would be valuable. It really is exactly as it was described in the beginning. It would make the reviewer's job easier.
You know, there are other comments here that I completely agree. Your recommendation about a Schedule 2 level is a term that's understood or should be understood by the bidders, and that would clearly provide uniformity.
Right.
And it would be unfair if somebody didn't know about it and is then thought to be penalized, etc. So, but
Could I ask another structural question that's probably as uninformed as the last one I asked? But what is the, what's the column marked order? Those numbers in that column, what are they?
You know, I will confess that I actually created this, and I used a spreadsheet that that someone had given us. I'm not sure what order is. So I just simply used it as a way of having a spreadsheet already with all of the questions.
Good question. So I think we just suppress that column.
Right. So we'll move it over.
Right.
Okay.
it does appear to be in order, though.
It's in order, yeah. But it starts at 49.
Jumps
right?
around.
Okay.
I had a quick question. One of my economic development questions, 317, doesn't have any PCI comment, which either means that the whole question is either really way off base or you just forgot to fill it in.
I'll actually check that. It could be, you know, I had a spreadsheet that had every question, and I was simply trying to leave in the ones that we had a comment on. I may have just left it in without a comment, but I'll check and make sure that we didn't.
Just even looking at the first two, 302 and 315, I'm certainly fine with those. I'm fine with those changes.
But this also starts to talk about, I understand there's been a couple of questions already posted by some of the applicants that are applicant-specific. I recall something about audited financial statements. If you are structured in a certain way, they may or may not provide some relevance. So we should think about how best to respond to those in as expeditious manner as we can, to at least provide guidance.
So that's a great segue. Thank you, Commissioner. So there were a couple of questions. We received a number of questions from applicants in the pre-application meetings. Many of those have already been answered, but we will issue a summary sheet based on our conversations, further clarifying what was meant by the questions. There were a couple of questions that I'll bring before you that rise to a little bit more of a policy matter, and the audited statements question is that. So we received the question of, we were asked how applicants can comply generally under item number 2.5 of our application. Under 2.5, we asked for an independent audit report of financial activities and interests for each of the last 5 years, including but not limited to the disclosure of contributions, donations, loans, and other financial transactions, and the like. So the question that we received was, how can applicants comply with this requirement, given that they may be creating a separate corporate structure for the mass gaming facility that will have no operating history? Their financial entity may or may not be a publicly traded company. Do they need to request a waiver from this requirement? And I think that's a question worthy of some consideration.
Yeah, no, and it's something, I don't have a particular answer. It's something that we should try to answer expeditiously, though. I think the intent was to get a sense as to the track record financially of the operator, but of the applicant. But many of these applicants formed a Massachusetts-based entity that has had almost no activity except for the purposes of submitting an application. So then the question becomes, at what level from the parent companies, and it could be more than one, of course, and that's where it starts getting complicated. Do you want us to submit? And it's something that we should try to answer soon.
And so I guess what I would say is if there are one or two or a couple of items that applicants need to adjust their applications before October 4th, that's probably something that they can do, even if we discuss this more fully at the next commission meeting of any, more concrete response or concrete recommendation from both
Right.
Pink and Co. and staff.
Right.
So, go ahead.
So in addition to that question, there was another question relative to schematic design. Item number 4 or 5 of our application states that please provide a schematic design as defined and understood by the AIA for each structure within the boundaries of the site, et cetera, et cetera. And the question that we received is schematic design per AIA specifications the required level? Would advanced conceptual design be more appropriate? And I think what this gets at is that a number of these applicants are trying to put together their final proposals in a shortened period of time, and perhaps they might not be able to reach that level of design for the application. And is that an absolute requirement or not?
Well, I can speak to that because I believe I had some authorship of that particular question, especially when we talked about that policy question. At the time, schematic design is, in my opinion, the earliest design phase that is better understood by the design community to have certain requirements. Anything before that may be a little, varies greatly. And by no means, I believe we meant that MEP, mechanical, electrical, plumbing, any kind of those installations be defined or submitted as part of this application.
We did not?
We did not.
Right.
However, we didn't want just a rendering
Right.
either. And so the question becomes, what is of most importance at the time of application? And it occurs to me that certain measures would be relevant, especially certain measures as in dimensions that the schematic design tends to have, particularly as they may pertain to a host or surrounding community issue. I'm thinking of an example. If the a developer has made promises that the structure is not going to be seen from a particular place, the highway or certain residential areas, the dimensions there are very important. So that then advisors can corroborate that, and then we can have some evaluation of that. But if that is not the case, then an advanced conceptual drawing may just suffice as well. So.
May I? So,
Yes.
as an architect, actually,
Great.
I think you've actually articulated that very well, and I would agree with you completely. And I would say that the clarification then in this case, which would be to say that it did not mean to include MEP, but it did mean to, in particular, include dimensional information that would have impact on community agreements, is a simple statement that even if it was only 2 weeks left, the Category 2 applicants could easily comply with.
Any objections to
No,
that?
no. I mean, reason why we shouldn't just do that right now.
Yeah.
Answer that question in that fashion.
Great. That's good.
So do you have do you have that answer? So do you have what you need?
I think I've got it.
Yeah.
That
Okay.
we're sticking with the definition and adding that,
Yes.
those two clarifiers.
Right.
Yes.
Okay.
And by the way, whether we make that part of, I don't want to create busy work, but whether it's better just communicated by an advisory or whatever the mechanism is
Well,
that
it's
is
just
most effective.
Yeah, it's just got to be sure to get out to everybody, to be fair.
I mean, I know many are following us, but I would hate that somebody goes
Yeah.
the extra mile to try to comply and didn't catch on to this
Mhm.
particular conversation.
Right.
Yeah, we'll get that out quickly. Just really quickly, just 2 more. One's not even a question. We received a question regarding what are the goals that are set by statute for MBEWB, Veterans Business Enterprises. There's specific guidance provided in the statute regarding Administrative Bulletin number 14. It's right included in the statute. So Jill and I have talked about that perhaps we should make that a little bit more widely available. I'm sure that everybody's reading the same law, but to the degree that this is an important matter, we should provide further guidance about what that says, and we can get that out quickly.
What, can you give us, what is the thumbnail of the guts of the issue here?
Administrative Bulletin 14 actually requires, let's see, Chapter 23K, Section 15 requires that construction labor participation goals for women and minorities be equal or greater than those defined in A&F Administrative Bulletin 14.
Okay.
And so that would be 15.3% for minorities and 6.9% for women. The legislation does not identify specific goals for the participation of minority business enterprises or women business enterprises. But we should make, I guess, clarify and make available Administrative Bulletin 14.
Okay. Good, that's helpful, thank you.
And
Is that something we could post? Would that be, yeah?
Yes, I have a PDF.
And the final matter is just a point of clarification. We've been asked whether or not all of the applicants are having conversations with the lottery regarding lottery mitigation. And we received the question whether or not any lottery controlled machines such as Keno would count against the 1250 slot cap. What I recommend is that Catherine and I will work to make it, we can make sure that we get a clarification on that item.
We'll review the statute and take a look at it and have conversations with the lottery folks if necessary.
And come back to us with something?
Yes.
Okay.
That's what I have on this item.
Okay, thank you.
Good day's work.
Yeah, good day's work. Good week's work. Yeah.
Good weeks.
Okay, our next item is legal report, General Counsel Blue.
Executive Director Day and I are before you today to talk about the Phase 3 regulation process and where we are headed with that. I would just like to refresh for the Commission the general process. We've been through this with our Phase 1 and Phase 2 regs, but as you recall, the process itself takes roughly 60 days, and that's 60 days from about the time that we provide the Commission with the first set of draft regulations. So in the phase that we're currently in, and I think, Artem, if you can move that to what's behind that memo, it might be a little easier to see. This is the scheduled checklist, and we've used this before. So essentially, these are the steps that we go through, and again, it's roughly 60 days from the time that we give the Commission the first draft set of regulations for your review, which means that we would plan on having something to you by the middle of October in order to have certain sets of regulations done by January 1st of 2014. So the process is the same. We will follow the process we have in the past. Executive Director Day will talk a little bit about the priorities, because I think that's where the Commission's interest is, and also what we need to determine to move forward.
Thank you, Catherine. Just for reference, in case you couldn't find it, was in yesterday's packet, and it's behind 6B2. If you're
From yesterday.
From yesterday.
From Wednesday.
Oh, excuse me. I lost a whole day in that process for some.
Wednesday.
On Wednesday, yes. And just as an introductory item, as we talk about it briefly, is I should note that we're aware that the Commission has requested, and we plan a broader discussion with the Commission regarding regulation development and priorities and policy topics that relate to those. And then, of course, with that, organizational topics that will relate to policy issues as well. So our discussion here isn't intended to address that more comprehensive package, and with any luck at all, we'll have that broader package for the Commission on the 19th at this point. But what we are looking is, the approach we're looking at taking, which is a little bit different than we have, is to bring the regulations kind of in a package that informs our ability to get ready when the casinos come online, that we will have a set of regulations that will support each section that might inform first their construction, but also when they come online, our ability to regulate that area. An idea or a concept of a package may be something like this slot machine standards, and how the commission may or may not approve those, and whether or not there's a lab or what kind of operation. We would need to have something like that ready to go in time that the applicants, the vendors who will supply them will be able to ship in particular equipment for examination and subsequently be ordered by the licensee to have to be placed in the case of the slot parlors. So we're trying to take a look at that rather lengthy list of regulations that we have before us and segment them into those kind of sections that will, and then bring that forward on what the commission would like to see going first. There are other areas that go along with that. We know there's areas regarding responsible gaming, workforce development, and some other miscellaneous areas that need to be probably worked in there, and the commission may have different priorities in that area as well. But we wanted to, I think if we can work on this package proposal, it will help us make sure the regulations are completed for each section that we need to develop the organization and get ready for the operation. What we have today is kind of in that case. As Catherine said, we know that it takes about 2 months. We're tentatively looking at getting a draft set of regulations for licensing to the commission on about October 17th. So my math isn't too strong, but that tells me we've just about got enough time to get that process done and have the regulations in effect for us to begin licensing after the first of the year. With that, we've proposed here about 6 policy questions, and I'm aware that in the past the commission has listened to policy questions, thought of policy questions, and then assigned them out if you thought there was additional research that needed to be done in return for a white paper and recommendation from, I think it was the commissioners, maybe staff in this case, unless of course you're prepared to just march on with that decision today, which works fine for us as well, just as long as we make sure we've got the commission informed and in the process about these decisions. I'm not going to read through each one all the way, but I wanted to give you a flavor of them and then kind of ask for your pleasures how you would want to move. The first one that's listed here really goes with will the applications come in directly for gaming licensees and registrants to the commission, or do we want those applications coming in from those who are either endorsed or already have a job essentially at the casinos? So that's the questions directly for everybody who wants to apply or originate through a gaming establishment. And the next one is key gaming employees. Is that an area that the commission, are we going to do suitability? We're looking at this from a suitability perspective on whether a license or registration is issued, or would we actually look at skills and education as well? Also, what the commission's direct role is in the licensing process. Is there a portion of it or a temporary part of it that is delegated to staff, or does the commission want to be specifically an approval level for all levels of gaming license applications? Gaming schools is another area, and concept of whether or not the commission would want to be involved in the licensing of gaming schools or in some kind of regulation of those schools as well. Key question, of course, is licensing registration fees, how we would actually calculate those. I think we're pretty close to a proposal on how that may be, but we want to make sure we run that by the commission to see if you think that's a fair place to start and how to start. And of course, the concept of whether the commission wants us to move forward with both a database but an application that's has its priority in online applications and online payments as opposed to a more manual process. And then I want to just make sure we check in. The commission had decided already that it wanted a 3-year license and then a renewal process. Just want to make sure before we go down the road with the regulations that is still what the commission is thinking is the best way to go. So that's the real quick summary of the issues that the policy issues we think are primarily involved in this upcoming set of regulations that we hope to have a draft to you by October 17th.
Is what you hope to have drafted by the middle of October just the first phase of the what we refer to as the phase 3 regs? And is there a bunch of other stuff coming hard on the heels of this?
Yes.
So there will be other key policy questions. The one that I keep referring to for example is whether we're going to have a lab or not. You know, this has been sort of kicked around, but it's clearly a key policy question, but it's not in here. So is there another set of key policy questions coming?
Yes. This is the policy questions that we thought were most important to get for you, so we can get those regulations to you by October.
Okay.
Actually, there will be a much longer list.
Right.
And part of it will be both the organizational questions, because there are more than just the lab, but also the priority on which sets of regulations should go forward.
Good. Well, go ahead.
Well, if there is still time for our next meeting to come back to these policy questions with a little bit more time to digest and research perhaps the context of how the pros and cons of how other jurisdictions may have approached some of these, I would be in favor of that. But if you think that you really need direction on a couple of these today, is that a question that you are posting?
I would, in posing which direction that the commission would like to go, I think it is very possible. For instance, if you want me, I could proceed to sign these out, select a select group of lucky volunteers, and then we could bring back that information to frame the issue a little bit better at the next meeting.
And would that still be timely?
Yes.
Yeah, okay.
Yes.
Yeah.
Yeah, as long as we do it by the next meeting.
Right. I would prefer that as well.
Yeah, so would I, for sure.
These are really, some of these are really important questions.
And it's delightful. Last time we did this, we assigned them out to the commissioners.
Right.
Now we're assigning them out to staff, which is much better.
Right.
Unless he was referring to the lucky volunteers.
It went without specification, yes. It's heavy on the volunteer.
Might get more thoughtful answers.
Yeah, no, I think that's definitely the way to go.
Okay. We will move forward like that. Thank you.
So where are we now? Is that, is that it for the legal report? Wow.
Yes, it is.
Okay. Do we, as you've now, Rick, you've been thinking about this a lot. As you're thinking about our schedule, do we need, we switched from weekly meetings to bi-weekly meetings, and so we can always switch back if we're starting to get cramped. Do we need to switch to more meetings? Do you think, do we have, in my mind's eye, I'm thinking that the 18th is becoming an awfully long meeting. Do we need to go back to weekly, or is the 2-weekly schedule still working for what you see in the pipeline for us to be dealing with?
I'd suggest that we stick with the 2 pre-scheduled commission meetings, so we can count on those times and dates and plan accordingly. But then what we have is we've had to supplement those depending on when the adjudicatory actions or other hearings. And it seems like to me that's probably what we'll have to continue doing for the Penn suitability. It's actually scheduled on the 18th. And then
and our meeting is the 19th.
The meeting's on the 19th.
That's right. Okay, so we've done it. Okay.
And that's what we've tried to do with each one of the upcoming hearings, is to schedule at least 2 days and then some period for deliberation as well.
Okay. I'm just going to say this sort of for the record, but today I had a morning meeting, and I felt there was an awful lot of stuff going on, and all of us have an awful lot of stuff going on. I talked about this with Karen, who's up to her eyeballs with hundreds of pages of background checks, legal department drafting regs, and we don't want to be so beholden to our schedule that we can't do these things properly and thoroughly. And I can feel it in myself, you know, that the brush to stick to the schedule is causing corners to be cut. I'm talking about myself, and I just want to make sure that everybody feels. I don't want to slip. I don't want to slip the schedules if we don't have to. They're important, but if you feel like we're pushing too hard and are not going to have the time to do the things we have to do in the way we want to do them, then we'll talk about the schedule. And I don't want people to be afraid of bringing that up.
Thank you, Mr. Chairman. That's one thing when we start talking about the packages of regulations that we've got, for instance, table games for an example. That probably doesn't have to come actually until very close to the opening of the casinos.
Right.
So I think it's really important to space that out so we spread the time and instead of trying to do it all at once and let everybody let everybody relax and work on a given area that we have to get a lot sooner. So I think that will help.
Right, okay, great. And it's not just the regs, it's everything, you know, it's the whole kit and caboodle of stuff that we're working on. Right. Okay, anything else on this topic first, or any other business? Do we have a motion to adjourn? Second? Second. All in favor? Aye. Unanimous. Thank you all.